We ready? Sige, good afternoon. I have 1, 2, 3, 4 items. I'll take them one by one so that makahabol kayo. First, in the matter of GR numbers 215-857 to 71, Mario Relampagos et al. Versus Sandigan Bayan, 3rd Division, and People of the Philippines. This is a petition involving the Sandigan Bayan's denial of the petitioner's challenge to the Ombudsman's finding of probable cause in relation to the petitioners. The petitioners had sought a temporary restraining order and/or a writ of preliminary injunction. The court today denied the application of petitioners for a temporary restraining order and a writ of preliminary injunction. Respondents were directed to submit their comment to the petition within 10 days from notice. Second item. In the matter of GR numbers 207-257, Honorable Ramon Jesus Paje versus Honorable Teodoro Casino et al. 207-276, Redondo Peninsula Energy Incorporated versus Honorable Teodoro Casino et al. 207-282, Honorable Teodoro Casino et al. Versus Honorable Ramon Jesus Paje et al. 207-366, Subic Bay Metropolitan Authority versus Honorable Teodoro Casino et al. The court took the following action. Unanimously voting 13-0, Brion Justice is on leave. Hardeleza Justice took no part due to previous participation as Solicitor General. The court voted to deny the petition in GR number 207-282, Honorable Teodoro Casino et al. Versus Honorable Ramon Jesus Paje et al. Voting 13-0, but with qualified concurrences by Justices Perlas Bernabe and Leonen, Justice Brion on leave, Justice Hardeleza no part due to previous action as Solicitor General. The court voted to grant the petitions in GR numbers 207-257, 207-366, 207-276 with the following effects. First, the January 30, 2013 decision and May 22, 2013 resolution of the Court of Appeals in CAGR SP number 00015 are reversed and set aside. The petition for writ of kalikasan, docketed as CAGR SP number 00015, is denied for insufficiency of evidence. The validity of the December 22, 2008 Environmental Compliance Certificate, as well as the July 8, 2010 First Amendment and the May 26, 2011 Second Amendment thereto, issued by the Department of Environment and Natural Resources in favor of Redondo Peninsula Energy Incorporated are upheld, and the validity of the June 8, 2010 Lease and Development Agreement between Subic Bay Metropolitan Authority and Redondo Peninsula Energy Incorporated is upheld. Third item. In the matter of GR number 216098, Bishop Broderick S. Pabilio, DD et al. Versus Commission on Elections et al. The petition for certiorari and prohibition with preliminary injunction is ordered consolidated with the petition for certiorari, mandamus, prohibition, and for the issuance of a temporary restraining order and or preliminary injunction in GR number 216070, Citizens for Clean and Credible Elections et al. Versus Commission on Elections. Respondents in both cases are directed to submit their comment to the petitions and the applications for TRO and or writ of preliminary injunction within a non-extendable period of 10 days from receipt of notice. Fourth item. In the matter of the two motions for reconsideration filed in GR numbers 209-287, Araulio et al. Versus Aquino III et al. 209-135, Sihuco Jr. versus Abad et al. 209-136, Luna versus Abad et al. 209-155, Villegas Jr. versus Ochoa et al. 209-164, Filconsa et al. Versus Abad et al. 209-260, Integrated Bar of the Philippines versus Abad et al. 209442, Belhica et al. Versus Aquino III et al. 209517, Courage et al. Versus Aquino III et al. 209569, Volunteers Against Crime and Corruption versus Ochoa et al. The court today, with Justices De Castro and Hardeleza taking no part, ruled as follows. I will quote, "Subject to the foregoing clarifications, the court partially grants the motion for reconsideration filed by the respondents and denies the motion for partial reconsideration filed by the petitioners in GR number 209442 for lack of merit. The dispositive portion of the court's July 1, 2014 decision is hereby modified as follows. Wherefore, the court partially grants the petitions for certiorari and prohibition and declares the following acts and practices under the Disbursement Acceleration Program, National Budget Circular number 541, and related executive issuance unconstitutional for being in violation of Section 25, Paragraph 5, Article 6 of the 1987 Constitution, and the doctrine of separation of powers, namely, A, the withdrawal of unobligated allotments from the implementing agencies and the declaration of the withdrawn unobligated allotments and unreleased appropriations as savings prior to the end of the fiscal year and without complying with the statutory definition of savings contained in the General Appropriations Act, and B, the cross-border transfers of the savings of the executive to augment the appropriations of other offices outside the executive. The court further declares void the use of unprogrammed funds despite the absence of a certification by the National Treasurer that the revenue collections exceeded the revenue targets for non-compliance with the conditions provided in the relevant General Appropriations Acts, so ordered, end of quote. As a last item, the court today has come up with a policy that on a weekly basis it shall also be announcing its decisions in administrative disciplinary cases involving lawyers and judges. I will be emailing some decisions of the court that have been arrived at today involving 3 lawyers. I will now take questions.
Yung culpability po ng nag-implement ng nandun pa po.
Okay. The court prefaced its decision today with subject to the foregoing clarifications. I am authorized to release a summary, and the summary will be given to you. But just so that we're all literally on the same page, clarifications made by the court. First, the court agreed with the argument of the respondents only on this point, that there is no constitutional requirement for Congress to create allotment classes within an item, and that what is required is for Congress to create items to comply with the line item veto of the President. The court agreed with that, and it said that there is no requirement in the Constitution or the General Appropriations Act that the subject of augmentation should be the expense category or allotment class. Accordingly, so long as there is an item in the GAA for which Congress has set aside a specified amount of public funds, savings may be transferred thereto for augmentation purposes. This interpretation is consistent not only with the Constitution and the GAAs, but also with the degree of flexibility allowed to the executive during budget execution in responding to unforeseeable contingencies. You will note, if you will compare with the court's original July 1, 2014 dispositive portion, the item C, quote, the funding of projects, activities, and programs that were not covered by any appropriation in the General Appropriations Act has been removed. That is subject of the clarification made by the court. So only 2 acts and practices are now considered unconstitutional. The 2 acts and practices, A and B, mentioned in the dispositive, modified dispositive portion of the court. The court also spoke to the issue of presumption of good faith, and the application of the operative fact doctrine. According to the court, the presumption of good faith stands despite the previous pronouncement, which is considered obiter. The court noted that insofar as its decision on that point, it made mention that the proper tribunals can make concrete findings of good faith in favor of those people who are sought to be charged only after a full hearing of all the parties in any given case, and such a hearing can begin to proceed only after according all the presumptions, particularly that of good faith, by initially requiring complainants, plaintiffs, or accusers to first establish their complaints or charges before the respondent can be made liable. On this point as well, the court made a decision to modify and clarify the language it has used insofar as those that are subject to the consequences of the operation of the operative fact doctrine. You may recall that in its July 1, 2014 decision, the court named 3 classes of persons: proponents, authors, and implementers. The court today decided to clarify the language by removing proponents and implementers and leaving only authors within the ambit of the coverage of its original language. The last point, programs, activities, projects under the DAP remain valid under the operative fact doctrine. And it is for that reason that the motion for partial reconsideration of the petitioner Belhica was denied. Take note that the motion of the respondents, which is government, has been partially granted, and only insofar as the third item is concerned.
In other words, sir, the doctrine on operative fact remains, but it is still up to the proper tribunals, of course, according due process to all parties, to determine good faith or bad faith.
Yeah, operative fact has actually very little to do with liability. The operative fact doctrine speaks to the validity of actions taken before a law or decree has been declared unconstitutional. And so the court, recognizing the effects of the projects implemented under the DAP before these acts and practices were declared unconstitutional, took note of the effects and said under the operative fact doctrine, it would be more unproductive or disastrous for the court to declare all of these projects as invalid, and therefore sustain those projects as valid under the operative fact doctrine. However, arising from the operation of the operative fact doctrine, the court clarified initially in its July 1, 2014 decision that proponents, authors, and implementers may be subject, to sanctions or liability because of the operation of the operative fact doctrine. In this decision today, the court has further clarified the language by removing proponents and implementers and leaving only authors subject to the language and always subject to the presumption of good faith, which according to the court remains and has not actually been removed despite the language of its original July 1, 2014 decision. Further questions? Okay na? Huh? Only authors, proponents, implementers are to be excluded from the operation, that particular phrase. If you will recall, I think that's in page 90, the controversial page 90.
You have to go back to the definition of
You
the
will,
decision of proponents and implementers, sir.
the original language of the decision, I think, would be important because that is the basis of the motion for reconsideration of the government insofar as good faith presumption is concerned.
So
Yes,
yung
Alex.
liability ay prospective, tama ba? Paano i-define yung auto-bill?
Ang mangyayari naman kasi dyan, Alex, pag nagkasuhan na, no, ang tinitingnan naman dyan is dun sa panahon na yon kung sino yung pwedeng may sala o di kaya pwedeng idemanda, no? So in the sense that when you say prospective, itong decision na to, ang interpretation nito, syempre prospective, hindi babalik eh. di ba? But ang tanong naman doon is yung acts kailan ginawa, di ba? And since it is now limited to authors, so yun yung siguro mahalaga doon. I-define kung at that point sino author.
So, ang liability sir, doon sa author lang.
Well, hindi ko pwede sabihin na liability doon sa author lang, pero ang coverage noong consequences, no, yung implikasyon ng operative fact, kasi valid po yung valid po yung proyekto Pero unconstitutional po yung dalawang acts and practices under the DAP, no, dalawa na lang batay dito sa panibagong desisyon, modified decision. Under the modified decision, dalawa na lang ang acts and practices na unconstitutional. Kung batay dito sa desisyon na to ay merong ma-identify na author, yun yung sinasabi ng korte na posibleng maging liable.
Sir, since naka-live ka ngayon, sir, would you define for the public, ano yung author? Sino yung author? Sino ang mga implementer? Sino yung proponent?
Antayin natin I don't want to define that because that is not my definition to make, no. As usual, the final text of the decision will be it's still being cleaned up, no. Tapos magpipirmahan pa sila. So I have been authorized to give a summary. The summary is it tracks very closely the language of the court. It is not the language of the court per se because posibleng magbago. But it tracks the language of the court and the reasoning of the court is there.
Or go back to or revisit the decision and see how it defines it.
Merong definition sa July 1. Siguro ang maaring tingnan dyan, balikan yung July 1, 2014. Tingnan kung ano nagbago. Ang pinakamalaking nagbago ay yung item C nung dispositive portion na wala na yon dito sa panibagong dispositive portion ng court today. Okay na tayo?
So, wala yung sa item C because precisely because there must be flexibility and leeway consistent, of course, with the laws on augmentation.
The court interpreted the provision on augmentation to mean that for so long as there is an item, no, and there's an allocation, and then that's already okay. Ang previous ruling nila is that kailangan may specific classes, no? So nireconsider nila yon. Sabi nila, hindi na kailangan yan. Basta merong item at merong pondo, pwede na yon. That's why the third item, item C, funding of projects, activities, and programs that were not covered by any appropriation has been deleted from the modified dispositive.
Sabi yung dalawang act ay covered ng operative facts yung binanggit niyo. So paano kung magkakaroon ng liability?
Again, Alex, ayokong sagutin ngayon dito, no? Kasi siyempre hindi naman po ako ang magde-determine kung paano yung ano. Ang sinasabi lang naman ng korte dito, hindi sinasabi ng korte dito na merong liable. Ang sinasabi lang ng korte dito, kung sakasakali man na meron, no, ang magiging sakop na lang ay yung author. Hindi na sinasabi dito na may liable. Ha? Malinaw tayo doon. Wala siyang sinasabi dito na may liable. Ang sinasabi niya, kung sakasakali man may makita, no, then only the author is covered. But subject, of course, to the presumption of good faith, because the presumption of good faith, which the court again reiterated, no, has not been removed. No, it is there as a presumption, it is there as a starting point, and therefore, kahit sino na government official ay entitled to that presumption. Yes, yes, yes.
Sir, na isang instance, sir, under the DAP, yung cross-border, sir, di ba merong funding din sa COMELEC, sir, may transfers of fund sa COMELEC under DAP, tsaka COA. Sir, doon, sir, sa COA and COMELEC, saan doon papasok ang implementor, ang proponent, and author?
Mahirap sagutin yan, Cecil. Specific yan actual na kaso yan Baka ma-quote ako dyan, no? Ganito na lang, no? Balikan nyo yung desisyon, July 1, 2014. I think the decision is pretty clear. Now, go to the modified dispositive portion. The modified dispositive portion still carries that item. That's item B. The cross-border transfers of the savings of the executive to augment appropriations of other offices outside the executive. It is still considered unconstitutional under the modified dispositive portion. Yun na lang pwede kong sagutin kasi pag sinagot ko ng diretso yan, baka ako'y mapahamak. No? Kasi actual case po yung binabanggit nyo eh. At hindi yan covered by the decision of the court. Alex.
Sir, kung in good faith yung author, yung other party ang kailangan mag-prove ng bad faith, tama po ba?
The presumption of good faith is a starting point. So, ang ibig sabihin ng presumption of good faith, pag merong magkaso ng government official, no, ang basehan natin is that good faith yan. No? Yung burden ay nasa nag-aakusa na ipakita na hindi siya in good faith. Okay? Yun po yung normal na application ng good faith presumption. Kasi nga ibig sabihin ng presumption ay yun yung pinakabasihan eh. Kahit na hindi mo nasabihin, nandiyan na yan. Parang presumption of innocence. Kahit na hindi mo nasabihin na ako inosente, pag criminal case, ang umpisa talaga natin ay presumption of innocence. So, ang sinasabi ng court dito, presumption of good faith is still there. No, it is there, it is operative, and that's why it clarified by saying, dun sa mga nagkiklaim na bad faith, kailangan naman talaga litisin pa yan eh. Sa korte, kung anumang tribunal, no? At dun sa paglilitis na yon, cargo ng nag-aakusa na patunayan na may bad faith. No? At pag napatunayan na may bad faith, dun siguro lilipat ngayon yung cargo. Nandun na ngayon dun sa government official. Ganun yung sinasabi ng korte. Yes, Tara.
So just to be clear, no, can we say that still the core, yung mga core mechanisms that were still parang unconstitutional, kumbaga, just
to be very clear, reflected naman doon sa dispositive portion ng court eh. Sinabi ng court, nung sa unang dispositive portion na July 1, tatlo lang ang unconstitutional. In-identify niya. Dito sa bagong dispositive portion, 2 na lang. Yung third item, basta may pondo at may allocation, okay na yon. Pwede na mag-augment. But within, of course, yung sarili mong branch. No, yun yung sinasabi ng court. Doon pa rin yun. Wala pa rin cross-border. Kasi bawal pa rin cross-border. Yes, Edu.
Alleged commission also by the Court of Cross-Border Transfer regarding the justice.
Parang meron. Can't find it, but it should be there somewhere. Kumana, but it's there. It did touch on that. I think there are copies already.
Sir, kasi the public kasi, sir, were very much aware, the public is very much aware of the wordings of the decision on operative fact, although it was the paragraph before the dispositive, so it's not in the dispositive. So clarify lang yun, sir, because in the previous decision kasi, it was as if the respondents had to prove the good faith, di ba? So, yun yung nasa quoting Justice Brion. That was in the July 1 decision. The paragraph prior to the dispositive. Para may striking lang.
Walang binago ina dun sa wording ng court. In fact, if I recall the decision that I saw earlier correctly, the court in fact quoted its original decision. It just clarified that this is what this language means. It did not change a single thing about that particular page. You know, if I remember again, I think it's page 90. Kasi 92 pages yung dating.
Change naman operative fact doctrine, diba? So, it will remain as a...
Well, operative fact doctrine remains, but I think what the Solicitor General wanted was to clarify the way that the court phrased its language, used as far as language is concerned. No? The court did not change the language. It said simply that this is what we meant by this language when we said that. Yun lang ibig sabihin. That's why the paragraph, the dispositive starts with subject to the foregoing clarifications. Okay? Anything else? Yes. Ano yun? Original.
Yung sa dispositive,
A, B, C, and then fourth yung last. Yung void pa rin yung last eh. Yung unprogrammed funds. Void pa rin yun.
so isa lang.
Isa lang ang natanggal. Kasi,
Yung sa original, sir, yung program funds was nasa first part. Wait.
nope, it's the same. The last.
Unprogrammed, yung unprogrammed, sir, no?
It's the last paragraph.
Oh,
Court further declares void. Still the same.
So yung C lang talaga.
Item C. Yeah. Ang alin? Tara? What do you mean mas matimbang?
There are more provisions declared on constitutional convention.
Only one lang yung ginrant.
Well,
C.
there is a partial grant only of the motion for consideration of the government. The rest is the same. The rest is the same. That's why I advised you earlier, take a look at the original decision, the original dispositive portion. Itabi mo dun sa bagong dispositive portion, which you will see in your summary. Because you will see the item.
Diba, sir? So sa dispositive lang naman, yung nag-grant sa kanila, sir, yung tungkol sa GAA.
Pag wala sa dispositive, then, well, that's not the judgment of the court. So as far as the judgment of the court is concerned,
Yung sa GAA.
the last item in the enumeration, ABC, no? Yung C ang nawala.
Yun yung nag-grant.
Mark,
Yung C lang talaga tinanggal.
huwag nyo na sabihin slightly relax kasi baka ma-mislead pa eh. Just use the language, let's just use the language that, partially granted. Partially granted. I think that's more accurate. Kasi mahirap pag sinabi mo slightly relax eh. Kasi parang half pregnant yan eh. Hindi, isa lang, Otara.
Can you also say that it's still unconstitutional?
Oh, yes. As far as the dispositive is concerned, the same acts, except for item C, are unconstitutional.
Sir, yung
Yeah, Ina.
item C, di ba, parang ito sa grant on item C, on the MR on item C.
Yeah.
As far as the operative fact doctrine
Everything is the
concerned,
same.
it's a clarification.
Everything is the same.
It's merely a clarification, it's not a grant. Correct, sir?
Wala sa dispositive yung operative
Yes.
fact.
So they just clarified the language in the July 1 decision on the operative fact doctrine, but it remains. Only item C was granted as far as the MR is concerned, so it's positive.
Yeah.
Correct, sir?
Yeah.
Thank you.
Right. Anything else? Okay na kayo?
Yung iba,
Oh. Yes. Vince.
may wording but sir will not entertain further
It is
remarks.
under the rules of the court. The court entertains only one motion for recon. No? So, well, hope springs eternal, but usually hindi ano.
Will not entertain further remarks.
No.
Dito, kukunin ko lang. Para may papaliwanag lang sa atin yung ilang clarification. Sandali sa.
Sige, okay.
Para magpatong-patong tayo.
Okay.
Yes,
Sir, quick clarification lang. So that means that all the programs implemented before the...
It was declared unconstitutional. Are valid. Valid.
Valid.
Operative fact lang. Operative fact lang.
So, basta every year before the decision,
Before it was declared unconstitutional.
pwede pa rin.
Pwede yan.
So, sir, who's
Operative.
who's considered the author, sir?
What do you mean?
Kasi
Ayan, hindi ko alam eh. Kasi,
it will be
siyempre,
up to...
it will be up to whoever wants to sue. Kasi siya yung magsasabi eh. Ito yung gumawa. Siya yung gumawa.
Tayo po sa court yun, diba?
Alin, what do you mean?